Welcome once again to Lehto's Law. Here's Steve Lehto.
Had a whole bunch of people send me this story, and a lot of stuff's been happening with our Supreme Court in the last few days. I will do a video about another big case the Supreme Court ruled on yesterday, but I'll do that in a little while because I'm going to spend a little more time digesting all of it, lengthy opinion and whatnot. But this case happened earlier. Supreme Court limits ability to enforce Miranda rights. Miranda rights. And those are the rights that you hear on television when Columbo arrests somebody and says you've got the right to remain silent, etc. Or when Steve McGarrett tells Dano to book him. That, of course, is the beginning of the process where you hear them say that. But more often than not, you hear book him, Dano, not so much the rights. From CNN, which did a very good job on this, Supreme Court limits ability to enforce Miranda rights, but there's been a lot of confusion as to what the Supreme Court actually did, so listen up. Tierney Sneed and Ariane DeVoe wrote this. The Supreme Court limited the ability to enforce Miranda rights to a degree in a recent ruling. They said that suspects who are not given their Miranda rights cannot sue the police officer for damages under federal civil rights law, even if the evidence was ultimately used against them in their criminal trial. What we're talking about is not the simple giving of the Miranda rights, but what happens if they don't give them to you? Because we all know that evidence can be excluded because somebody wasn't given their rights. And this case was about whether you could sue them for failing to read you your rights. So the court's ruling will cut back on an individual's protections against self-incrimination by barring a claim for damages. So it's barring a lawsuit, but it does not address the criminal side. It also means that the failure to administer the warning will not expose a law enforcement officer to potential damages in a civil lawsuit. It will not impact, however, the exclusion of such evidence at a criminal trial. A lot of people see the headline and see the Supreme Court ruled against somebody with respect to Miranda, and they go, oh, Miranda's been thrown out by the Supreme Court. No. And the Supreme Court routinely issues very, very narrow rulings on very, very narrow issues of law. Not always, but sometimes. And here the narrow issue was, if they didn't read you your rights, could you sue them for that? Supreme Court says no. Court clarified that while the Miranda warning protects a constitutional right, the warning itself is not a constitutional right, because if it was, that would trigger the ability to file the lawsuit for civil damages. Now, Steve Vladek says today's ruling doesn't get rid of the Miranda right. He is a professor at the University of Texas School of Law, but it does make it far harder to enforce. Under this ruling, the only remedy for a violation of Miranda is to suppress statements obtained from a suspect who's not properly advised of his right to remain silent. But if the case never goes to trial, or if the government never seeks to use the statement, or if the statement is admitted notwithstanding the violation for some odd reason, there's no remedy at all for the government's misconduct. But I think most people assume that the remedy for the misconduct was to exclude the statement if somebody gave it without knowing they had the right to remain silent. 6 justices signed on to this and said that a violation of the Miranda right is not itself a violation of the Fifth Amendment, and that we see no justification for expanding Miranda to confer a right to sue. And they're pointing out that up till now, no one had the right to sue over that. So somebody was trying, they said, no, we're not going to expand it. They're not reversing something. They are simply not expanding something. Meanwhile, Kagan joined the other justices in dissent, said that the court's ruling was stripping individuals of the ability to seek a remedy for violations of the right recognized in Miranda. The majority here injures the right by denying the remedy. Case involved a hospital worker who was accused of a crime which he later confessed to, but then he later said that his confession was coerced, he hadn't been given his warnings, and I believe he wasn't even convicted in the case, but that's where this all came from and led up to being in front of the U.S. Supreme Court. Lawyers for the police in that case, of course, say the man's statement was entirely consensual and voluntary, and he was not technically in custody at the time, while his own lawyers contended he was bullied into confessing in a windowless room. And that's one of the other things. You take criminal procedure in law school, which I did a few years ago. They talk about all of these different definitions. And is it custodial? If they walk up to you and start talking to you, are you in custody? If they bring you into a room and close the door, are you in custody? If they bring you into a room but don't close the door, are you in custody? If you walk into a room and the police officer is sitting down and there's a table here and you simply are standing in front of him and he never said you can't leave, are you in custody? And so there's a whole bunch of things that go into determining exactly what it means to be in custody, having a custodial interrogation, but that's not the point here. The lawyer for the police officer here said that the man couldn't bring his claim because establishing a violation of Miranda does not establish a violation of the Fifth Amendment itself. Miranda creates a procedural rule barring prosecutors from introducing and courts from admitting certain unwarranted statements as part of the prosecution's case in chief at a criminal trial. They wrote in court papers. In their opinion, the Miranda warning is a constitutional rule, but it is not a right, and under that interpretation, a lawsuit cannot go forward. Miranda does not prohibit taking unwarranted statements. It merely forbids the admission of those statements at trial. And that's their position, and that's the one adopted by the Supreme Court. They said that an appeals court ruling that went in favor of the man bringing this case, who was the defendant in the criminal action, would saddle police departments nationwide with extraordinary burdens in connection with lawful and appropriate investigative work. Any police interaction, according to them, could give rise to a private lawsuit, even where the police officer has acted entirely lawfully. Meanwhile, of course, the attorneys for the police side of this commended the court's ruling, saying it confirms that the deputy cannot be sued for his good faith effort to investigate the crime. As the court explained, the landmark Miranda decision establishes an important prophylactic rule protecting the Fifth Amendment right against compelled self-incrimination, he added, but the failure to give a warning does not automatically equate to a violation of the Fifth Amendment. And again, that's the attorney who is speaking on behalf of the side here, representing the police. Meanwhile, the Solicitor General of the United States argued in court papers, because the Miranda rule concerns the introduction of evidence at trial, a suspect may not sue the police officer under Section 1983 for violating that rule. Lawyers, meanwhile, for the man at the center of this argued that the police officer refused to accept his denials and that with a hand resting on his firearm, he threatened to report the man and his family members to immigration, which the man took as a threat. Now, he had a green card, but deportation could lead to persecution in Cameroon, where he was from. Paul Hoffman, a lawyer for the man who's a defendant in the lower case, said that the police officer was the central actor in the chain of events leading directly to the statement being introduced at trial. And like I said, oddly, the man was not convicted. But then, of course, what they said was, well, he did make this statement without being Mirandized. And that was probably one of the main reasons he got prosecuted. Now, he wasn't found guilty, but the fact he's prosecuted is an ordeal. And so the man wants to sue for what he had to go through, because if he'd been Mirandized, this is how the thinking goes, he wouldn't have made the statement. And the Supreme Court is saying, yes, you have the right to be Mirandized. And the remedy for a failure in that would be to bar the admission of evidence gained from that. It doesn't create an independent cause of action. And so keep in mind, I've talked about this before, the courts handle largely two different kinds of law. I'm talking about the courts in general. There are lawsuits or civil actions, and there are criminal actions or prosecutions. So if you're being prosecuted for a crime, you are in the criminal system. If you are suing or being sued, you are in the civil system. And so the Miranda warning and all that arises in the criminal setting. And so they're saying that you already have a remedy in the criminal setting, because if you weren't Mirandized, you bring the motion to have the evidence suppressed, right? That's your remedy. And the Supreme Court is saying, if we allowed you to sue for the failure to be Mirandized, we're creating a new cause of action, because heretofore it has not been recognized as such, and we decline to do that. We're not going to create a new cause of action so that you can sue somebody who doesn't Mirandize you. Okay? So I hope the distinction is clear. And like I said, they didn't throw Miranda out. They didn't reverse Miranda. All they said was, Miranda's over here on the criminal side. We're not going to create a civil cause of action for Miranda over here. And I understand that there's policy issues on this. And some people are going to say, but Steve, if the police know that you can't sue them, and the worst that's going to happen is the evidence won't get in, what's to stop them from not Mirandizing and just seeing what they find out? Well, that's what's been going on ever since Miranda got passed, quite a while ago. And the police have always had to make that decision. Do we Mirandize this person or don't we? And most of the time it seems that they do, and there you go. So as of right now, you cannot sue the police officer for failing to Mirandize you. However, you can seek to have that evidence suppressed at trial. So the story, like I said, is from CNN. I read several versions of it. I think their write-up is pretty good. I'm going to get at least one person who says, Steve, I don't believe anything CNN says. To which I'd say, well, please point out something they got wrong. Tierney, Sneed, and Ariane DeVoe wrote that Supreme Court limits ability to enforce Miranda rights. And it was sent to me by Ryan, David, Scott, Chris, Tim, Maj, Nathan, and Tequila. Thank you very much. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. They don't know that we know, they know we know.